We need you to take action now to protect your Second Amendment rights. The Second Amendment is under attack like no other time in history. Joe Biden and Kamala Harris have pledged to take away your Second Amendment rights through gun bans, gun confiscations, and government regulations. Radical gun legislation has already passed in the House and now headed to the Senate for a vote. Joe Biden has taken action through executive orders. You can help protect your Second Amendment rights by texting JOIN SAF to 474747. The Second Amendment Foundation is the oldest and largest nonprofit foundation focused on protecting your Second Amendment rights. We urgently need you to text JOIN SAF to 474747 or go to joinsaf.org. Your right to own a gun is on the line. Text JOIN SAF to 474747 or call the 800 number on your screen right now.
Hey everyone, welcome to another edition of the Daily Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, it's been a while since we've talked, but I'm glad to have Alex and Mike Ooley of the Ooley Law Firm joining us again today. They are my go-to guys on Friday. We talk about the Second Amendment and the law. It's because of my health problems. It's been several weeks since they've been on. Guys, thanks for coming back and joining us again today.
Glad to be back. Thanks for having us, Paul.
Good to be with you, Paul.
So when we set this up, actually when we set up you coming on several weeks ago, what we wanted to talk about was New York State Rifle and Pistol Association versus Corlett, the case that has been accepted for SCOTUS for this fall. First thing I wanted to ask you guys about that case is there was one way it was presented that they wanted the Supreme Court to take it up, but the Supreme Court said, well, we're going to look at it, but we want to look at it a little bit of a different way. And do you guys think it's good that they opened it up to all of may issue, shall issue, or is that kind of a risky thing they did?
Yeah, so what you're referring to is the question presented to the court for review. And the question presented by the petitioners in this case was modified slightly when the Supreme Court decided to accept the case for review. And it's hard to say exactly what that means, but if we're looking in a crystal ball and trying to guess about what the court might be doing with that, I don't think it's necessarily a bad thing. It does limit the question a little bit, and I think it might help a little bit just to consider the question presented versus the question that the Supreme Court is going to take up. So the question presented is what's called a facial challenge to the law in the case. So the question was whether the Second Amendment allows the government to prohibit ordinary law-abiding citizens to carry handguns outside the home for self-defense. So as you can see from that question, it's a pretty broad question and would have wide implications if the Supreme Court were to answer that question affirmatively, saying that people do or that the government doesn't allow ordinary law-abiding citizens to carry handguns outside the home, or that they do allow ordinary law-abiding citizens to carry outside the home. So that was the question presented. The question accepted, though, was more narrow, and it's an as-applied question. So the question that the court accepted was whether the state, in this particular case, whether their denial of the petitioner's applications for concealed carry license for self-defense violated the Second Amendment. So it's more narrow, not quite as broadly applicable, but I think that's there may be a number of reasons for why they did that, and we can talk about that if you like.
Yeah, I mean, it's just conjecture on our part, but I suspect that it was part of the negotiations that the justices had with respect to coming to a consensus and an agreement as to whether or not they would even accept this case or not, because both parties presented questions that were quite different than what the Supreme Court actually decided was going to be the question in front of them. So there are commentaries I read where folks, once again, I think it's just conjecture. There are folks that are brighter than me, but nonetheless, I really think it's conjecture at this point. And we need to focus on the fact that it's been over a decade, and we finally have a case in front of the Supreme Court that can really produce some good now that we have Justice Barrett there to perhaps relieve some anxiety that we've had as pro-Second Amendment folks with respect to whether Chief Justice Roberts would see things the way that we think they ought to be viewed in terms of the Second Amendment.
Well, and the way I read things is the way that there's two ways this could go. We can either keep the status quo, or May issue could go away. And if May issue goes away, the benefit that no one seems to be talking about, yes, California, New York, New Jersey would all be affected, but so would Puerto Rico, Guam, Hawaii, a lot of outlying, the territories, any place that's under the U.S. Constitution now becomes shall issue. And I think that's a huge benefit for anyone living anywhere that is supposedly under the Constitution but really doesn't have a right to keep and bear arms.
Yeah, that's a great point, Paul. I mean, and bear in mind, I mean, I know you know this, and most of our listeners do as well, but the Second Amendment recognizes a natural right that we have to self-defense, and that the use of a firearm is a natural extension of that right. But it's a right, it's not a privilege. And these May issue schemes treat the Second Amendment as a second-class right, as more of a privilege than a right. And to the extent that the Supreme Court does rule that broadly in a way that would preclude these May issue schemes, that would obviously be a very positive step forward for the rights of many law-abiding Americans.
Yeah, I think Heller, at least in my estimation, was clear that it indicated that handgun possession was essential to self-defense, and self-defense rights are protected by the Second Amendment. So the question now, we hope that this case answers, is whether these May issue states that basically put in place bureaucrats who try to determine whether or not you have a, quote, proper cause, I think is what the terminology is in New York, to carry a handgun outside the home for self-defense. I mean, ultimately, that's the kind of commonsensical question that we want answered, and I'm optimistic that we're going to get good news in that front probably next early summer, probably in June.
Yeah. DJ Playnice has a question. There are 6 conservative justices right now. Potential impact of that makeup. And DJ, I'm going to correct you a little bit. I think there are about 5.5 conservative justices right now. What do you guys?
Who's the half, Paul?
Roberts is the half, I think.
For sure. Yeah. But to that question, I think the reliable supporters of the Second Amendment on the Supreme Court would not want to take this case if they didn't think they had a reliable 5th vote. And that may be why the question presented was modified slightly, so that they might be able to more reliably get that 5th vote. So I'm optimistic that it will be a positive decision. The extent, I guess, of that decision is what's in question. Will it be more of a narrow decision that's more or less only applicable to New York, or will it be more broadly applicable? So that's what we're waiting to see.
Yeah, we certainly have 5 justices: Thomas, Gorsuch, Kavanaugh, Alito, and Barrett. And of course, Roberts is, I don't know about him on the 6th. I'll certainly agree with you.
One thing that I wasn't aware of, but I've read since this got accepted, I didn't know apparently there's a rule of 4 that when their discussion is up, whether the Supreme Court is going to take a case or not, that 4 of the justices have to vote to take a case for the case to get accepted, so that there is at least a chance for a ruling.
Yeah, that's it's kind of an interesting tradition. There's no law or statute of any sort, or even a Supreme Court precedent that says that's the way it needs to be. But that's sort of the tradition of the court, that if 4 justices, when they're reviewing these cases, deciding whether or not to accept a case, that if 4 of them want to accept the case on cert, that they'll accept the case. And that's what's, like you said, called the rule of 4.
Okay. So if I want to make sure that I'm right here. If they rule the way we hope they're ruling, the Supreme Court makes determinations and it affects the entire nation, or could they put down a ruling that only affects New York and doesn't affect New Jersey, California, Hawaii?
Yeah, so that they could certainly make a more narrowly tailored decision that could have some effect on other states with similar regimes, similar licensing processes, but they could make a decision that's more narrowly tailored to the particular situation in New York, which would be less broadly applicable across the country.
They certainly could do that, but, and once again, just my 2 cents, I can't imagine that there was a decision to take this case and just decide it on very narrow grounds, on very narrow facts. That would be an enormous waste of the Supreme Court's time to do that, and I certainly hope that's not going to be the case.
Yeah, I agree. And courts across the country, federal district courts and courts of appeals, have been asking for more guidance with respect to the Second Amendment in the wake of Heller and McDonald. So I agree that a narrow decision would seem to be a waste in that respect as well.
Yeah, I think the gravity of the place in history that we're in right now is very important in terms of Supreme Court jurisprudence with regard to the Second Amendment. I think because Heller said that Mr. Heller had a right to have a handgun for self-defense in the home, and we certainly think that means you can keep. That's consistent with the verbiage in the Second Amendment that you have a right to keep a handgun for self-defense. But we've still got this other word in the Second Amendment that says you also have a right to bear arms. So we need to, that needs to be addressed as well. And certainly the Second Amendment wouldn't say you have a right to keep and bear arms if it was only applicable to the confines of your home. Certainly bear means when you go out the front door. In all the places where crime is more likely to occur, we also have a right to bear arms there as well. So it's just incredibly important decision that's left unanswered in the judiciary in this country. And there is, I think, I won't say confusion, I don't want to show any disrespect, but there certainly is some disagreement amongst the circuits, I think, as to what bear means outside the home.
Yeah, and that's a good point too about keep and bear. There's this rule of interpretation called the rule against surplusage, which means if there are 2 words that could be interpreted in the same way, they shouldn't be, because why would you include 2 words that mean the same thing? So to the extent that keep and bear could be interpreted to mean the same thing, they shouldn't be, because that would be a surplus of vocabulary in that particular phrase. So I think it's consistent to say that keep means that you have the right to keep arms in your home, and bear them means that you have the right to carry them on your person outside the home.
All right.
So not only do we need to have the right better defined, but we also need to, I think the circuit courts around the country also need to understand whether or not there's going to be different levels of scrutiny applied to the right to keep and bear arms or not, or whether there's simply going to be a very simple, historical, contextual, originalist interpretation of the Second Amendment. That's another area that I hope the Supreme Court weighs in on as well, and they'll probably maybe have an opportunity with this case.
DJ Playnice asks, in New York, it is proper cause. Have there been any significant challenges to it already that might be good for the cause?
So with respect to decisions that have already been handed down by other courts, I believe there is some precedent there that could be helpful. But one thing I want to mention about that is that here in New York, one of the petitioners here, his name is Nash, I forget his first name, he provided information that there had been a string of recent robberies in his neighborhood and that he had gone through significant amount of training. So even with this information demonstrating what clearly would be proper cause, to the extent that you need to show it, he was still denied. So that's really the question. I don't know that there's any other precedent that demonstrates sort of a disregard for people's rights to that extreme.
Yeah. And I'm not a New York lawyer. I suspect there were state court cases interpreting their statute. I'm not familiar with those. Obviously, there were cases here that have led this to the Supreme Court. The Court of Appeals and the District Court made decisions. But I think the question actually points out the real problem, and that is we don't know what it means. And we're leaving these decisions about whether a state may issue a license or not simply to the subjective discretion of some purported public safety official of some sort that's going to make decisions about how you defend yourself, how you protect your God-given right to life, liberty, and the pursuit of happiness. And we, at least in my mind, we don't need that in this. We don't need a bureaucrat deciding how I'm going to protect my life in this country.
And that's key, because a lot of these places, it's the chief of police, an appointed position, that is deciding whether or not you get a carry permit. Not the sheriff that's elected, but the chief of police that's appointed, and a political position, and is never up for election. So yeah, that's
and in this case,
I think these it just eventually what I'm hoping for is that the Supreme Court gets a case and says a permit is that shall not be infringed means shall not be infringed. You don't need a permit for a right, is what I'm hoping eventually happens.
Yeah, and that's a great point, and that's, maybe Alex can comment on this, and that's what we need some guidance from the Supreme Court, and hopefully it is that sort of originalist, basic, commonsensical analysis that you just articulated. Shall not infringe means shall not infringe.
Yeah, there's some discussion about what mode of scrutiny should be applied to certain rights. And the justices in the Supreme Court, I think, at least some of the conservative justices, don't think that we should apply the same sorts of modes of scrutiny analysis that we do to other rights, because the Second Amendment is clear. The right to keep and bear arms shall not be infringed. It shouldn't be subject to some interest balancing test like what's sometimes called strict scrutiny or intermediate scrutiny. It should be subject to an analysis based on the text, the history, and the tradition of the Second Amendment. So are the restrictions in place today the sorts of restrictions that would have been acceptable at the time that the Second Amendment was adopted? And I think that should be the extent of the analysis when reviewing restrictions on our right to keep and bear arms.
Yeah, because if you look at other areas where the courts try to determine are you going to apply strict scrutiny, intermediate, or rational basis test, it just becomes this quagmire that is very difficult to wade through eventually after enough court decisions are made in a particular area.
One more social media. We've given some great comments in here. I got to ask, have they ever been to Canada and compare legal matters to the USA? Canada is far worse, and that California, it's amazing how bad it could happen in the USA. Well, Warsaw Patriot, they don't have our Constitution in Canada. Specifically, they don't have a Second Amendment in Canada. And so they abide by their Constitution, and until the 1950s, they still had a queen. So,
yeah, it's a great point. It's a good question. When I was in Canada, it's been years and years ago, and didn't really think about the Second Amendment at that point in time because I was very, very young. But fortunately, I did have the opportunity to be in East Berlin and in Europe before the Berlin Wall fell. And I can tell you that that experience certainly created an appreciation in my heart for what the Second Amendment is trying to do. When you're in East Berlin and you know that the folks have incredible fears of government, it certainly you recall those things when you talk about things like the Second Amendment and the Bill of Rights in this country, and it certainly fosters an appreciation for it.
A great point, another comment, and a great point coming in here. Spartan 6 says you should not have to pay to exercise a right either. That goes straight to, with voting, poll taxes were ruled illegal. Well, I would think that paying to have a permit to carry is nothing but a Second Amendment version of a poll tax. I'm not a lawyer. I don't pretend to be one, and did not stay at a Holiday Inn Express last night. So,
yeah. I mean, can you imagine if we had to go to the local county courthouse and give them $100 or send a check to the state, and so we could get a certificate to put on our wall outside the door of our home and say we've asked permission, and we've paid our fees so that we have the protections of the Fourth Amendment against unreasonable searches and seizures. Mm-hmm. We don't do that. I mean, people would be outraged by that. So
I went down and paid me $100. I can have my internet hooked up so I can talk on Facebook now.
Maybe if you haven't been put in Facebook jail.
Yes. That's exactly right. One more comment if I could, guys. We're getting some great comments in here. Diane Houston, May issue is not acceptable. They can pick and choose who they want to have a permit. And I want to go to one specific example for that, and that is San Francisco County, California. When I started doing the Polite Society podcast, there were 3 permits in San Francisco County. Dianne Feinstein had one of them. So there you go.
Yeah, that's a great point. I mean, these May issue licensing schemes are very arbitrary and subject to a lot of abuse by local bureaucrats. So definitely, if that's not an infringement on your right to keep and bear arms, it'd be hard to say what is.
Exactly. So is there anything else we should know about New York State Rifle and Pistol Association versus Corlett? I mean, it's not, the oral arguments aren't even scheduled until the fall session, right?
Right. Yeah. The brief by the petitioners is due in July, and I believe the respondents' brief is due in August. So that will give us some idea about what the oral arguments might look like in the fall. So that'll give us kind of a preview. So you can look out for those. Actually, a good website to kind of keep track of these things is SCOTUSblog.com.
Yeah.
They have a nice kind of resource there with a timeline of what's gone on with the case.
Yeah, and I don't know, we've got it somewhere, but I think that's pretty cool. You can go there and, instead of filtering through the media, you can actually go there and read the briefs of the parties, the amicus briefs. If you really want to educate yourself, that is a great resource. You can go there and read it and keep up on it. And it's good to read that because there are going to be other cases out there. I'm hoping there'll be a case that challenges some of these magazine bans in places like New Jersey. So it's good to keep on these things, educate yourself, and then it applies to other cases as well. And you can talk to folks about it in an educated way and maybe bring them to our side. So certainly encourage folks to go to that website.
We've got about 5 minutes left. I want to bring up, and I didn't tell you guys I was going to do this. I want to bring up a couple other stories. They are kind of legal related, but I didn't have you guys prepare for these. So if you don't know anything about them, you're totally you're off the hook for commenting on them. But Second Amendment Foundation, my boss Alan Gottlieb, yesterday filed a federal challenge to the Illinois ban on anybody 18 to 21 having a carry ban. You have to be 21 to get a permit in Illinois, and nobody 18 to 21 can get a permit. SAF filed lawsuit on that yesterday.
Yeah, that's an interesting case, and one, just by example, that could be impacted by the outcome of this New York case potentially. I mean, if the court decides or shows that the way that the Second Amendment is going to be interpreted going forward is by the text, the history, and the tradition, I mean, would people 18 to 21 years old at the time that the Second Amendment was adopted have been subject to these types of restrictions? And, you know, that would be the analysis there. And I think the clear answer is no.
I don't even think 16-year-olds would have been.
Right.
Yeah. And I saw that case was filed. Kudos to the Second Amendment Foundation for doing that. It seems sort of rich to me that we send 18-year-olds to Afghanistan and Iraq and places like that all around the world, and yet with firearms and munitions of all sorts, and yet they can't be trusted with a firearm in this country to protect their own life, liberty, and pursuit of happiness. So I hope the Second Amendment Foundation is successful there.
The one other story I wanted to mention, and this just crossed my attention this morning. Earlier this year, Montana passed and the governor signed permitless carry. As part of that, they said that no part of Montana will be required to have a permit to carry concealed anymore. And the Board of Regents that rules the state's college system lost their minds, ran to the court system, said, hey, you can't do this because it's college. And the state Supreme Court said, go away, boy, you bother me today, and just dismissed it. So good news if you're 18 to 21 and you live in Montana and you're going to college, you can now defend yourself.
Yeah, it's weird that university faculty and administration think that your rights should be different at the university than anywhere else. But so it's kind of a rich position to take.
Yeah, exactly.
Yeah, every state has these progressive enclaves. We have one up the road with IU. So I'm certainly familiar with the reaction to conservative politics in the state of Indiana. We certainly get a different reaction from Bloomington than we do from most of the rest of the state, that's for sure.
All right. Well, we are just about to the bottom of the hour. Gentlemen, thank you for going into the deep dive into the SCOTUS case. It's always a pleasure to have you guys on and to talk about these legal matters with you.
Yeah, thanks for having me again, Paul.
Thank you, Paul.
You bet. Folks, I want to encourage you again. Next week's going to be a little bit of a short week. We've got the Masada Youth Group training here in Sioux Falls. I'm only doing the show Monday through Wednesday next week. But please do come join me Monday through Wednesday next week, 5 o'clock Central Time, for the Daily Bullet. Thanks again for watching, everybody.